Yeah, it's the craziest thing, man. They just went back like a zillion years and found an old as dirt case, and bam, they vacated the judgment. There was no fraud, there was no duress, there's no mutual mistake, and don't even get me started on section 1401.
Blah 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 blah, hurt duress, blah 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 blah, blah 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 blah, 1401, blah 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 blah, duress, blah blah. Hair club for men.
Even any due diligence. And Sophie? Believe it or not, my daughter did her own stunts. Hello again, hope you're all doing well. It's fair to say most lawyers would probably rather jump out of a moving vehicle than deal with a 1401 pleading, but paradoxically, they're one of the most appealed rulings, and each state has its own version of it. If you're new to all this, 1401s are just, well, they're special pleadings that are designed to vacate, undo old judgments, and Illinois' version applies to both civil and criminal proceedings. Now, today's case deals with an unhappy wife who vacated her divorce settlement by arguing an excuse that it hasn't been used in over 30 years. And now that it's back from the dead, it's one that I think might have opened Pandora's box. A common misconception is that 1401s are limited to fraud, duress, mutual mistake, voidness, and those two subsections that address certain types of felony convictions. I say misconception because these three are creatures of cobbled together case law. They're not mentioned anywhere in the 1401 statute, just examples of a meritorious claim or defense. Remember, the goal of a 1401 is to save an innocent party who was rocked by an unjust outcome. With that said, these three cover nearly all the acceptable reasons, nearly being the key word, because today's case dusts off an old wild card basis to vacate, which works as a, well, kind of a break glass in case nothing else fits reason. And that case is actually two, weeks 1 and weeks 2, the revenge. Before we get to the key facts in today's wildcard case, I want to give you just a really quick update on the guide. I'm wrestling with InDesign at the moment, trying to get it finished really close to the finish line. The guide has separate sections for things like self-defense, because not every case of self-defense is self-defense. It has cases on expert testimony, appellate tripwires, kind of nuanced things like extension requirements, void orders, because it does happen, mens rea requirements. It's not a treatise, but it's no longer a pamphlet either. When it reaches advanced copy stage, it's almost there. I'll provide another update on the Substack, but for now, just take my word, unlike J.R.R. Martin's Winds of Winter, this one is coming. And with that said, back to today's case. So here's the key facts in a nutshell. Obviously, always read the decision. The divorce was filed and proved up in 4 days. The wife never got a lawyer. The negotiations happened in the office of the husband's attorney. The lawyer for the husband and the judge and the parties appeared unclear what the marital estate was actually worth.
That seems wrong. But wait, there's more.
This was a high net worth divorce. The parties are residents of Franklin County, but it's filed in Saline. The settlement gave the wife of a 26-year marriage about 17% of the assets. And finally, something I thought was very important but doesn't get much discussion in the decision. During the lead up to the divorce, the wife claimed the husband went ballistic on her and that she was intimidated. And while in the lawyer's office, she was pressured into signing this agreement because if she fought it, the husband allegedly claimed the lawyers would take all the money. The reason I found this interesting is that, well, longtime viewers may recall this video that I did that discussed economic duress as a basis to vacate. However, that's kind of a missed opportunity because as you read the decision, that theory doesn't get developed here. The ex-wife's allegations don't touch on fraud or mutual mistake either. And her 1401 languishes before the trial court, then it goes up on appeal, then goes back down again, where the judge eventually grants the vacatur due to a wild card reason that we'll get to in a moment, and that the MSA was unconscionable, which then goes back up on appeal. Okay, so to reverse the judge on appeal, the ex-husband has to meet what we call the Dresden Dolls test, because I love using tortured analogies. You see, a judge or jury being wrong by itself is almost never enough to win on appeal. They have to be wrong enough to meet what we call the standard of review. From the hamburger test, when we apply the abuse of discretion standard, to the pool shot for de novo, Each issue provides a range of wrongness that the appealing party has to show. The Dresden Dolls test applies the manifest weight. This is actually the most common standard that you're going to see in both state and federal court appeals. In this test, the test is actually quite simple. You just pick one, just one, of the Dresden Dolls' top commercial songs. You know, the kind they still play on the radio, assuming radio still exists. Now, you have a few to choose from because despite being perhaps the top punk cabaret duo, they also had their share of commercial hits. So you might be thinking, Coin-Operated Boy or maybe Sing. And if radio's played anything longer than 4 minutes, Delilah would probably be up there too. Now, coincidentally, they just re-recorded Yes, Virginia. I pre-ordered a special autograph vinyl edition. It's probably made from recycled cigarette ash and cheap whiskey bottles. But my point is this. The Dresden Dolls test isn't one answer. It's actually a range because unlike the hamburger test for abuse of discretion, we're not looking for something that's outside the bounds of reason. We're just looking at the record. So if the judge or jury had picked 672 or Modern Moonlight, where Coke and Pepsi finally found a compromise, now the radio airtime for those is going to be manifestly inopposite to their other works. It's one where a contrary result would be apparent. So in other words, the appellate court isn't asking whether My Alcoholic Friends should have been picked by the judge or jury in lieu of, let's say, Coin-Operated Boy. They're asking, are there sufficient facts in the record that at least back that outcome, even if they might have picked a different song? So, with that hurdle out of the way, let's see how the appellate court ruled in today's case. Now back to Weeks. The appellate court affirms the vacatur for two reasons. One, the agreement was insanely one-sided. 17% of a multi-million-dollar estate after 26 years of marriage is, well, something that's unheard of unless there's a prenup involved. Plus, two, drum roll, the wild card reason. The unusual circumstances surrounding the formation of the MSA. Now, both reasons combined result in the affirmation of the trial court's vacatur. What's shocking to me is that the wife waited up until the 2-year deadline to file her 1401. Now, some lawyers erroneously treat the 2-year statute of limitations for 1401s as, hey, just make sure you file before the 2-year period. That is usually fatal thinking. Case law says you must show due diligence, meaning as soon as you find out, you run into the court for help. There are so many decisions where a party filed within the 2-year period but still had their case tossed because they sat on their hands for months or longer. But here, the trial court finds the wife failed to exercise due diligence. That should have ended the case, but then says, don't sweat it. And under this wild card reason of unusual circumstances, the 5th Appellate District was fine with that. So with all of this, why is this a Rule 23? Well, that's because there's some precedent, which I'll get to after this quick message.
If you're bald and fat like David, you can't do anything about the former. But you can slim that waist down and help out the best legal aid charity in Illinois by signing up for Res Judicata on August 13th.
And I hope to see you all there. Now, turning back to our case, the judge pulled out old school case law, European TANSPA Incorporated, which uses the term unusual circumstances, but that comes from its summary of another case, Halley v. Robinson. Now, Halley never uses that term. European TANSPA does to summarize what happened in Halley. And in Halley, which is an auto accident lawsuit from like 1982, the plaintiff's attorney talks to the defense attorney who hasn't appeared in the case, but they indicate they might file what's called a limited appearance. Talk to some old lawyer over 50 as to what that means. It's an old case. The plaintiff's lawyer even sees the soon-to-be opposing counsel in the courthouse on the day the case is on the call. But the plaintiff calls the case anyways, asks for a default, doesn't tell the judge about this interaction with defense counsel. Defense counsel isn't there, so it's defaulted. The following month, the plaintiff proves up the default, gets $150,000, and then sends a copy of the judgment to the defendant 31 days later.
That's suspicious.
Yeah, in my view, defense counsel should have been on the ball because you do have a duty to keep track of your case. That's actually the case law. That goes for both the lawyer and actually the client as well. But sneaky behavior, aka unusual circumstances, led to the judgment being vacated anyways, and that's affirmed on appeal. There were other unusualities in Halley, but the opinion as you read it just zeroes in on counsel's conduct, which wasn't fraud, but definitely underhanded. So this wildcard reason comes into play when you have a unique or a really crazy fact pattern that doesn't fit with the other traditional reasons, but if you can prove it, compels vacating the judgment. Now, I only have one issue with Weeks: the complete discardation of due diligence. I'm not sure if discardation is a word. I'm just going to use it here. I can see waiting a month. I can see maybe waiting 2 months, but nearly 2 years? Yeah, man, what I have noticed as an appellate lawyer is that once you let one in, others always follow. So we will see maybe a bunch of people run to court now under this much friendlier reason to vacate, or maybe we won't. I guess we'll have to wait and see. Whew. Before we close, I wanted to share my best memory of Judge Bellows. Now, this was years ago, back when I was still doing trial work. I'm on the 16th floor of the Daily Center, chilling on some Angry Birds, waiting for my case to get called. And this lawyer steps up and he hands her this stack of papers, says, hey, Judge, we got a settlement here. Go ahead and take this one off the call. And then politely insinuates that she doesn't need to read what she was handed. Well, she's going to read it, and she's going through the whole thing, and without even looking up, she quips, not that I don't trust lawyers, but I don't trust lawyers. And as soon as she said that, the pro se section in the back just busts out laughing. But it was comments like that that set the tone for her courtroom. Whether you were some big shot lawyer or just some working class stiff, everybody was equal before her. You will be missed.